every month that they had not been paid, and I had no defense in the case, so I suggested strongly to the county administrator that he pay those bills to avoid the litigation and to avoid the additional expense of the additional interest that would have to be paid. And I did not know whether he would honor that suggestion, because in fact the board had not been able to make a final determination on this matter. My reading of the record was that attempts to cause these bills to be paid failed on 3-3 tie votes every time it came to the board. So for that reason, I suggested that since the county administrator did have the authority under the act, under the policy, and that because we would certainly lose the litigation if we had been sued, and we would also have to pay the additional costs of the interest, that we attempt to avoid all of that, so that we could use our time in more positive ways. Yes, sir.
As you can see tonight, I've been saying, I know 2-3 times, that's why I'm saying what I've been saying tonight. We don't fully understand something that we have on paper and have in policy, and we grab it and then we got it. Then when it comes down to taking action, you say, well, here, it's written here, how many people understood that? So if everybody had understood that, the bill would not have been gone 9 to 10 months. And you could have done it 2-3 months earlier when it started. So nobody knew enough to understand what it really meant in that.
Well, Ms. Caper, I take issue with that. I understood what was here.
Well,
when we discussed this policy, back in October. But I understood. When we discussed this policy, it presented in the absence of the board, emergency, how we would be able to handle it without having a board meeting. That's what it presented. And that's why I made the motion to approve it. That's why now, if that was the case, prior to getting an attorney, why would they call and ask for approval? If you have authority to do it anyway. You have a policy, you could have done it without calling. And that's not a position, but nevertheless, the point it's done, and we have to move on.
Well, Mr. Chairman, the point is, as the attorney pointed out, it has not been exercised before. But in this particular case, because I dealt with these 3 attorneys, Mike dealt with those 3 attorneys, they weren't threatening suits. So in the best interest of this county, somebody's got to look after the county. Even if somebody doesn't understand what it means, somebody's got to look after the county. That's my responsibility, right or wrong, good or bad. Make a decision because it's in the county's best interest, which is part of what I was hired to do, as I recall. Well, now what I've heard tonight is all we want to do is make sure that we can make a decision, whether we understand it or not. The regular board with the bylaws, which should have been done back in January, by the way, the next board will have served over half its time by the time we get to the end of 22 pages.
And I'm going to tell you something. The truth of the matter is, even related to the issues, I've been a long time on the board. Never took that long to approve policy, even in October, because we was somewhat moving on one accord. But something happened after that time, would generate distrust, in my opinion, and it can cause a stalemate. And I'm saying, even though we may have the liberties, but there's something, sometimes you have to, what are the intent of the policy is you have to maintain the integrity of the policy. Well, listen, that's what I think. But listen, it's after 12 now. We can move on. I'm asking a motion to adjourn because it's late. It's late. We'll validate our policy because it's after 12 o'clock. Yes, sir. Yes, sir.
Before you adjourn, I don't remember that we certified the closed session that we came out of because we were running over here. So it's necessary for the board to consider resolution under section 2.2-3712 of the Code of Virginia. That resolution indicating that the purpose that you went into closed session earlier tonight was for the purposes stated, and that it's allowable under the act. If any member of the board wishes to speak against it, they may so speak against it. Otherwise, a motion to pass the resolution is in order.
Can we have a motion?